Good day, everyone, and thanks for joining us for today's seminar from Incompetence to Misconduct, Discharging the Burden of Proof in Just Cause Cases. So while I introduce myself and our speakers, please see the information slide that is on your screen. I'd like to draw your attention to the survey piece. We value your feedback, of course, on our sessions, and we encourage you to fill in the survey before you log out of the webinar today. So take a moment to do that, please. It's very useful to us. My name is Paquette. I am a partner in Fasken's Toronto office. I'm joined today by two colleagues, both partners as well, Boris Subara, who is in our Ottawa office, and Raphaël Buruiana, who is in our Montreal office. Now, all of us practice in the field of labor, employment, and human rights. We all have a very broad practice advising clients in both unionized and non-unionized environments. All of us do litigation, so we represent clients in court, in grievance arbitrations, human rights tribunal, and so on and so forth. And we do really a whole range of things, going from advisory work to workplace investigations and so on and so forth. So I won't dwell on mine or Boris's or Raphael's distinguished bios, but we're very pleased to be with you today. And on that note, let me turn to the agenda, which might appear quite daunting today, but you'll see that we are following the title of the presentation. So what we've done is we've chosen a number of cases that we thought would be of interest in the fields of employee incompetence, so that sort of termination, misconduct while on duty, and since we are getting those questions quite often, termination for misconduct while off duty. And lastly, we will discuss briefly some human rights predicaments that come into play when you're considering a termination for cause. So it is quite a jam-packed agenda. I understand that many of you have already provided us with some questions ahead of time. We thank you for those. We're obviously not going to be able to broach each and every one of them, but we hope that the nature of the cases that we chose are going to answer either directly or indirectly many of your questions. We will be saving some time for questions at the end of the presentation. And on that note, let's talk a little bit about our first team, which is employee incompetence. And just one thing that I should say right off the bat here. So we've chosen a variety of cases, as I mentioned, from different jurisdictions. And some of those cases are in the unionized world, so they're really grievance arbitrations. And other ones are the traditional cases decided by judges. The good news is that while there are differences in vocabulary between arbitrators and judges, on the whole, you will find, and it's the same thing for those of you who are federally regulated, I think on the whole, you will find that the law of dismissal in Canada is relatively uniform. And so whether I'm speaking or Boris or Raphael, you can take back some of those lessons, whatever environment it is that you're operating in. Now, on employee incompetence, I will admit that it is a very rare event in the life of a lawyer, and certainly in the life of business professionals, where we are successful in proving just cause for incompetence as opposed to something that we can label as proper misconduct, okay? Incompetence is viewed differently by arbitrators and judges because it's not quite voluntary. A person simply can't do the job. They don't have the chops, if you will. They don't have the skills or the ability. And so judges are very hesitant, and arbitrators as well, to allow for that sort of termination and disentitled employees to statutory entitlements or reasonable notice of termination at common law. So let's turn to the next slide, which is really just a reminder before we look at some cases about the law of termination for inadequate performance. First of all, the standard that you have to meet as an employer, it is not a standard of perfection that we must expect of employees. We must measure them against the ability of a reasonably able, skillful, and efficient employee in the position. So reasonable here, reasonably able, that's a very important word, right? So we are measuring them against someone who's probably more in the middle of the pack as opposed to the top performers in their particular department. And additionally, against that particular backdrop, you have to meet all of these requirements to be able to convince an adjudicator that there is just cause for termination. So again, you have to establish reasonable, keyword, and objective standards of performance, right? Things that can be measured, right? Not things that are done arbitrarily or on a whim. So again, when we talk about being reasonable, when we talk about being objective, that means you can't set up an employee for failure. You can't give them targets and goals that they're never going to be able to achieve. You also have to be able to demonstrate that the employee has failed to meet those standards. Now, that means that you have to show that it is in fact the employee's fault, right? If there is a recession, if you lost a lot of client accounts through no fault of the employees, you're going to run into a very serious problem if you're trying to blame the employee for failing to meet the standards. You have to demonstrate that the employee has been warned that their employment is in jeopardy if they don't continue to meet the standard. And that is where we often bump into problems, Boris, Raphaël, and I. It is rather shocking how employers often sugarcoat the issues that they're encountering with employees, or they kind of sandwich the bad between good things. And so employees get a little bit confused. The message isn't clear enough that their job is on the line. So for all the positive things that we want to bring to their attention, we also have to remind ourselves that we have to be crystal clear about the consequences of their failure to perform. And finally, we have to be able to provide reasonable time to correct the situation. Now, everybody hates that word reasonable because it means different things to different people, of course. But let me give you a bit of a guidepost. It is trite to say that a probationary period is about 3 months, right? That's the law of the land everywhere, and that's for new employees, okay? So you can imagine that for employees who have seniority, they've been with you for a long time, the more you go, the more time they should be given to improve their performance. So my rule of thumb is you're going to be giving employees most of the time, and of course there are exceptions. People can make very grave mistakes. I'm not talking about that. But for employees who consistently underperform, you're going to want to give them a solid 3 to 6 months. All right? So that's what I mean by reasonable time. And sometimes you may be stuck extending that period for one reason or another. Perhaps the employee has improved but is not quite there. So you're going to give them a bit more time to show you that they can do the job. Perhaps the employees have been on vacation or they were absent on a leave, and so you couldn't quite observe them for 3 to 6 months. So again, there is some flexibility involved here. Now, let me just say, and I think that Raphaël will probably make that point more elegantly before I give him the proverbial microphone here, but it is often, and I think it's a fair question for employers to ask themselves, how much do they want to invest in this process of managing the performance? I think it's a strategic question that is worth asking at the outset. It's a business decision as well, right? Are we going to wait 6 months for nothing, right? or are we better off considering paying the employee, right? Because that's the law. You can terminate someone if they're not doing the job, if they don't meet your expectations, but you have to pay for it. So on that note, let's switch slides, and Raphaël, the floor is yours.
Thank you, Christian. Everything that Christian said regarding the rules in Ontario are the same that apply in Quebec, or should I say they were the same up until that case we're going to talk about right now. So in 2019, up to 2019, there were 5 criteria to terminate an employee for incompetence, which were the same that Christian just discussed. They had been provided by the case law. There was a Court of Appeal decision in 2005 that confirmed those criteria, and they stayed pretty much the same. And employers were always applying them when terminating an employee or missing one of the criteria and losing their case. Recently, in this case, the employer followed exactly those 5 criteria to the letter, no problem there. The arbitrator confirmed that the employer had followed the 5 criteria, but raised the application of a 6th criterion, which, of course, the employer didn't know about and did not apply in that case. So basically, in this case, you had an employee who worked for the Kativik School Board for over 10 years. Performance had always been average to good. There was no real problem. The employee had then been transferred to a new position where the employer saw a lot of difficulties on his part, created a performance improvement plan, gave the employee time, energy, resources to improve. The employee did not improve, at which point the employer offered a new position to the employee, which the employee again refused, and he was then terminated. In this case, although all the criteria were met, the Court of Appeal confirmed the decision of the arbitrator, which was that, well, the employer should have created or applied a 6th criteria, which was determining whether there was a reasonable alternative solution. In this case, notably, putting the employee back in his old position where he was successful, or in another available position at the school board. So before the Court of Appeal, the decision was whether the arbitrator failed to respect the applicable rules by creating that 6th criteria, and the Court of Appeal confirmed that the arbitrator was entitled to do so, to add that criteria. If we move to the next slide, on the same day, the same bench of the same Court of Appeal rendered a decision that confirmed that only the 5 first criteria applied in a decision regarding, it's a Murray G versus Sinclair, but it's essentially a McGill University case where McGill University had terminated an employee, a teacher who had 37 years seniority, 32 years as a tenured professor, had been there for a long time. For many of those years was a very good employee, no problems. And in the past years, certain problems had started to be seen, notably with regards to the employee's ability to use new resources such as emails and electronic and informatic items. So the employee was asked to provide a proposal for the classes she wishes to give to students. That was not done or was not done appropriately. She had then follow-up meetings where we were discussing with the university whether that employee could do something else, whether she could provide different classes, whether she could write papers, submit papers for grants. None of those became satisfactory or came satisfactory to the university, who then decided to terminate the employee. So before the Superior Court confirmed that the university had applied the 5 criteria correctly and that the dismissal for incompetence was appropriate. Before the Court of Appeal, the same day as the prior judgment, the Court of Appeal did not discuss that 6 criteria, did not evaluate whether McGill had an obligation to see if that tenured professor could do another job, and simply confirmed the first decision. So what does this mean for employers? Basically, Well, to the question, is there a sixth criteria that you need to take into consideration when terminating somebody for incompetence? The answer is sometimes yes and sometimes no, which is the most hated answer ever. And because you either you apply that sixth criteria all the time and then you hope that you can meet all of those criteria, or you decide not to apply that sixth criteria and hope that the arbitrator or judge will apply that majority case law that there's only 5 criteria and not 6. And since those 2 cases were granted or were made published in 2019, there were several new cases that applied either the Kativic case and applied 6 criteria, and others that applied 5, which again makes employers a little bit hesitant to terminate somebody when there is another position the employee could use or could work in, but we don't necessarily want to offer it because our mind is a little bit already made that the employee is not a good employee, and we don't want to just move the problem around to a different position. So just like Christian said before passing me the microphone, I believe also that this will have the impact of forcing employers to offer amounts of money that are substantial for employees who are incompetent to sign a release and not sue the employers. It's something that we already have been seeing for the past few years. And I think this 6 criteria is something that will likely have the impact of causing this situation to be even greater than what we saw before. That being said, I pass the microphone to my colleague Christian to speak about another case.
Thank you, Raphaël. So that was an interesting case because there's some success for the employer. Now let me tell you a little bit about what not to do when you're trying to make a case for dismissal. And granted, this case, Chu versus China Southern Airlines, which is very new, is also rather unique, I will say, because of the egregiousness of the conduct of the litigation. But in any event, this was a plaintiff who had worked in a marketing position. He had worked for the airline for about, I think it was either 8 or I think it was about 10 years. And at a certain point, a new manager came into place. Oh, we're just going to go back. There we go. To Chu. Thank you. So a new manager came into place, and this employee, Mr. Chu, was not terminated, but he faced demotions and a pay cut. So he went to 2 different positions for which he wasn't trained. So remember at the beginning of the presentation, I said you can't set somebody up for failure. Well, this is an example of that. So he went to a customer service position after taking a pay cut, and he was not trained or qualified for that position. The judge said that basically there was insufficient evidence led at trial for the employer to rely on incompetence with respect to that particular position. Essentially, there was an affidavit from a coworker that stated that she had made certain observations and that there had been a complaint about his service from a customer. So that was hearsay, in other words. So very, very weak evidence in that regard. And in any event, the employee was moved a second time to a different position. And that was an airport terminal job, a very physical job. And I think it's important for everyone to understand that this employee was 67 years old. So he had certain limitations, right? Working inside the airport terminal was quite different. It was a physical job. It required him to move quickly, to act quickly, to sometimes run from one terminal to the next, to be stuck doing night shifts, depending on schedules. And the court was very hard against the employer in this case. Again, faulted the employer for not having trained the employee appropriately. When they trained him to do that job in the airport terminal position, they had employees basically with timers, stressing him out, timing him to do certain tasks. The training was somewhat perfunctory. He was expected to learn on the job. And ultimately, a piece of evidence that came out during the trial was a performance work summary, where it became clear that the employer itself knew that the employee at his age, at 67, was being put in a position that was physically demanding and difficult for him to accomplish. So it's a very long decision, but for our purposes, the long and the short of it is that there was clearly insufficient evidence to terminate the employee, particularly given the lack of training, the fact that we didn't meet the criteria that I mentioned in the beginning, giving him essentially very clear indication of what he did well, what he did wrong, what our standards and expectations were, coupled with, like I said, a lack of training and a very difficult work environment. He was essentially set up to fail. And there was even more egregious conduct on the part of the employer, where they pleaded certain things, retracted them, which essentially led the judge to believe that he had been purposefully set up to fail so that we didn't have to pay him severance. So they awarded reasonable notice, $50,000 in aggravated damages, and another $100,000 in punitive damages, which far exceeds what this employee would have even gotten if he had been terminated without cause by several multiples, given his salary. So I will leave it at that. And Boris, sorry, it's me again. We'll go to the next slide. So all this to say, few takeaways here. Do I have to use a performance improvement plan before terminating an employee for incompetence? No, you don't, but it's quite a good tool to have to make sure you check all the boxes, as we discussed earlier on. Should I discipline the employee, or is this incompetence? There are two different aspects here. Incompetence is coaching. It's performance improvement plan. That's the direction you're going in. Misconduct is the more traditional discipline that you're all accustomed to: a letter of warning, a reprimand, possibly a suspension, and so on. Okay? And sometimes what I would invite you to consider is that you have a given set of circumstances that meets both. There's an element of perhaps insubordination and an element of incompetence. And you can move in both directions at the same time. Because as I said earlier, it's very difficult to terminate for incompetence. And so as an employer, you want to make sure you've got these two kind of tracks for discharge that you're moving forward on, because you may be able to prove the misconduct piece before or more easily than you can prove the incompetence. And lastly, when can I impose a demotion, and can I change my mind about what I do with an employee? Technically, a demotion, and this is subject to what Raphaël was just discussing about this very innovative case law from Quebec, which we're all going to be keeping our eye on. Normally, when you impose a demotion to an employee, you can't do it unilaterally, right? It is a constructive dismissal. The exception to the rule is when you can actually prove that you would have been able to discharge the employee. Then this is considered to be an alternative where the employee can take on another job, mitigate their damages. So you could do it in those circumstances. And about changing your mind, I would simply caution you that it is possible to, once you've perhaps decided that you were going to terminate without cause, because it's too difficult to reach the cause level, you could change your mind. You could get evidence after the fact, but it is very risky. If there is any whiff that this was a circumstance where the company was willfully blind or knew that something was wrong but didn't investigate it at the time the employee was there, this opens up a little bit like the Chu case. That opens up the employer to a potential award for punitive and aggravated damages and so on. So tread carefully, and we'll come back to the human rights a little bit further at the end of the presentation. So next slide is on-duty misconduct. And I will skip through the next slide because I will invite you to essentially read those on your own time. But these apply to unionized employee and non-unionized employee. You have to always, when you terminate for misconduct, and Boris is going to talk about a case right now, you have to be able to prove that the misconduct occurred and that the capital punishment, so to speak, of termination of discharge, depriving the employee of their entitlements of common law and under statute, is proportional. That's really the key word, proportionality. And the courts, as arbitrators, will look at the circumstances of the case, right, including the length of service of the employee and so on. And they will look at these factors that are written right here in front of you, even though these are well established in labor law. Courts do actually look at these things in practice. So Boris, on the next slide, if you will.
Thank you, Christian, and good afternoon, everyone. I'll be talking about COSAR v. the Canadian National Railway Company, or CN Rail, which comes to us from the Court of King's Bench of Manitoba. And again, on the topic of the sufficiency of evidence, this is a case that deals primarily with an employer's ability to rely on an investigator's report to oppose a wrongful dismissal claim. So this is a case where a former manager at CN Rail was fired for cause following an investigation because he allegedly had failed to adequately respond to a complaint of harassment by a female employee. Mr. Kozar, being the former manager, was 61 years old and had been with the company for 34 years. And prior to this, had never been disciplined. There were never any performance issues in his case. So what happened is there was an incident involving a female employee and her male coworker. Both of these employees reported to Mr. Kozar, and he himself was not directly involved in the incident, nor did he witness the incident. But the female employee complained directly to HR about some remarks and comments that had been made to her by the male coworker. HR intervened and told Mr. Kozar, "Don't worry about it. We're on it. We're going to look into this. There's nothing you need to do in relation to this incident." But Mr. Kozar wasn't happy with HR's response or with the guidance provided to him because both employees reported to him and he wanted to do something about it. So he decided to meet both employees in his office, one after the other. And having reviewed the facts and the incident, he determined this would not interfere with their ability to keep working together in the same workplace. So as a result of that, as a result of Mr. Kozar's comment, the complainant brought a second complaint, this time against Mr. Kozar himself, alleging that he mishandled her complaint and failed to disapprove the actions of the male coworker. So CN, in accordance with its workplace harassment policy, hires an independent third-party investigator to investigate the two complaints. And the investigator does conclude that Mr. Kozar did not intervene to stop the remarks and the gestures of the male employee and did not do enough to express disapproval to the male employee. But the report doesn't recommend that Mr. Kozar be terminated necessarily. In fact, there are just no recommendations from the investigator, which is a common occurrence in these types of cases. But despite that, the company decided to go ahead and fire Mr. Kozar for cause. And the termination letter, all they did is they copied and pasted the contents of the report, deeming that he failed to follow CN's safe work policies that prohibit harassment and so on and so forth. The problem with this is that CN, when it came time to argue this case in court, they did not lead any evidence from, first of all, the employee who made the allegations against Mr. Kozar, nor from any witnesses. But even more problematic was the fact that CN did not present firsthand evidence or recollections from any employees involved in the decision-making process. Next slide. In fact, CN was unable to offer any evidence that any of the management employees involved even read the report. Never mind that they had relied on the report or conducted a fair and contextual analysis as required by law. The only evidence linking the decision and the termination were those excerpts that the company copied and pasted into the letter. So while CN did rely on the investigators' findings, the report itself was not put into the evidence by way of an affidavit from the author of the report. It was simply attached as an exhibit to the affidavit of an employee who was not involved in the decision-making process and who had no knowledge of the report until after the fact. So really, the court determined that this was hearsay evidence. And while the rules of civil procedure allow for hearsay evidence, the court was not prepared to attach any weight to this report simply because Mr. Kozar had no effective means of challenging the conclusions of the report because this was a summary judgment motion. And so the court was really extremely critical of the process followed and the employer's reliance on hearsay evidence. That was simply not enough to meet the very high burden of proof typically required to demonstrate just cause. And as both Christian and Raphaël just explained, it is difficult to terminate for cause in Canada. The legal tests and procedures to be followed place a high burden on the employer, and building a defensible case requires time, as we heard Christian say, a well-organized step-by-step process, either progressive discipline or an investigation process, and finally, strong proof of the grounds relied upon and the process followed. And in this case, there simply was not a well-documented process. We simply did not have any individuals with direct knowledge of the relevant facts. And so what this could mean for you, if ever you are involved in a workplace investigation, is that you may have to call the investigator at trial to provide testimony because relying on the report alone may not be enough in the sense that the plaintiff, in that case, wouldn't have the opportunity to challenge the investigator's findings in front of a judge. And here, because the employer was unsuccessful, the employee was awarded 24 months of notice, which is not surprising given that he had been there for almost 35 years. Next slide. Now, I'm also going to touch briefly on another example of on-duty misconduct, this time surveillance of employees more generally and time theft. So in Bessie v. Reach CPA, this is a case that comes to us from BC. The employer terminated an employee for cause after finding out that the employee had engaged in time theft while working from home. The employee had been employed for less than 6 months, and after the employee started working from home, the employer installed a time tracking software called TimeCamp on her work laptop. And sometime later, the employer became concerned about a few timesheet entries the employee made because those did not match the time tracking software's data. And the data showed a discrepancy of about 50 hours, time which the employee claimed she had worked, but which was not reflected in TimeCamp. And following an investigation, the employer concluded that the employee had not worked those hours and should not have been paid the associated wages and proceeded to terminate the employee for cause. And when the employee challenged that decision and filed a claim for wrongful dismissal, the employer in turn counterclaimed against the employee and sought to recover the wages the employee had been overpaid. And so the court reviewed the records at hand and determined that TimeCamp had accurately recorded her activity. And even though the employee could use the work laptop for personal use as well, that software was sophisticated enough to distinguish between work activity and personal use. And it was clear looking at the evidence that the employee had not worked those 50 hours. The court concluded that she had engaged in time theft, and that led to an irreparable breakdown in the employment relationship, and therefore just cause was appropriate, and the employee was not entitled to any severance pay. What's interesting as well is that the employee was ordered to repay the approximately 50 hours of wages that had been overpaid. And also interesting is the fact that the court did not insist that, the employee required some sort of warning or anything like that. This was simply, the first time the employer learned of the events, and that was enough to erode the relationship between the parties. Now, the court also did not criticize the employer's use of time tracking software, which is interesting. The employee was aware that the software was installed and that her computer behavior was being monitored. Now, this case was decided in BC. In Ontario, we should note, if you have 25 or more employees, you do, and if you are in fact tracking your employees in any way, through any electronic means, you are required to have an electronic monitoring policy as required by the ESA. This is a relatively new requirement since 2021, and that policy must describe how and in what circumstances you are monitoring employees, and must also provide the purpose for which you are collecting that information. Next slide, and Raphaël, over to you.
Thank you, Boris. So yes, in the following case, the question that will be answered is, can an employer terminate an employee who lies to the employer on a few occasions? And the reason why we inserted that case is that over the past years, we have seen several cases where first instance courts conclude that an employer did either prove the lie or prove the fraud or prove the action of the employee, but did not prove the employee's intention to commit that fraud or otherwise breach his or her duty of loyalty, and therefore grant the employee's grievance or their case before the courts. So this case we found interesting because it went the other way around. Essentially, in this case, you have an employee who works for Hydro-Québec, and his duty is he's an essential worker during COVID. His duties are responding to 911 calls, power outages, and other calls for people who are in the province. It's a 24/7 job, so it's a team that has a rotation, and the employee on several occasions told the employer that his wife was working in Ontario, and because it was COVID, he had to stay home with the children, so he could not work certain shifts. Now, Hydro-Québec had a policy and a procedure where, in certain situations such as those, employees were remunerated and had a paid leave of absence during that time. So during a few weeks, that lie continued to be repeated. It was not a one-time deal for that employee. He kept repeating it several times over a few weeks. And during an investigation, the employer asked him to provide information and confirmations that his wife was indeed in Ontario, documentation to that effect, which the employee was incapable of providing. So the employer determined that the employee had breached his duty of loyalty, had lied to the employer on several occasions, and that the bond of trust had been irretrievably broken. Now, the arbitrator did conclude to a premeditated lie that the employee abandoned his team to their fate, that the facts, that he did not admit to the facts, and he only did so at the trial, but he did so even then reluctantly. The employee expressed no remorse, no regrets, and deemed his actions to be reasonable in the circumstances. all situations that would normally lead to dismissing the employee's grievance. However, the arbitrator characterized the griever's lies as errors of judgment and considered that he had been entangled in his lie, and therefore he had to say it again and again and again in order to persist in the lie, in order not to get caught. Therefore, the arbitrator granted the grievance and substituted its 18-month suspension to the termination. This case was then brought before the Superior Court, which concluded that the arbitrator's decision was unreasonable and that arbitrators and first instance deciders have to stop victimizing employees and taking away their sense of responsibility. The judge added that in the world of work, honesty and integrity are non-negotiable values. They do not change according to circumstances. And that's one of the core obligations of an employee, is to be loyal and faithful to its employer. So this is a very nice decision for employers who, over the past years, we had seen many cases where we basically had to prove the employee's intention to fraud to do something like that. So it's a good decision to shift maybe the case law we had seen in the last few years. And just one note on investigations. Often employers will use the fact that an employee lied during an investigation as an aggravating factor in imposing a disciplinary measure, whether termination or not. But a case such as this one reminds us that the lie in itself can be a cause for discipline. So it can be an aggravating factor, but you can use it also as a separate ground, which is a violation of the duty of loyalty and can justify in certain instances termination. That being said, can you please change to the next slide, and Christian can take it from here.
Okay, thank you. So just a few things to keep in mind here, and I'm going to take this opportunity to answer a few questions actually that I've seen on the chat. So first of all, somebody asked about whether or not employee write-ups eventually, without discipline, become condemnation of an employee's bad behavior. And when do these written warnings become stale? And I think that kind of touches probably that first point here, which is on the slide. What about fireside chats with employees, right? Where you're not necessarily giving them a formal written warning, you're coaching them, right? You're warning them that you might get to discipline if you don't shape up. And there's no problem with fireside chats per se. You can rely on them at the time of giving discipline, but you can't skip the disciplinary process altogether. It comes back to the original principles that we talked about earlier, which is the employee has to know that there are consequences to their misconduct. And so fireside chats, useful tool. Definitely make sure that you make a note of those fireside chats, because what they will help you establish is that the employee was made aware of the company's expectations and did not meet them. But it cannot be substituted for the process that we've been discussing. Now, someone also asked whether or not there was truly a distinction or an advantage to a probationary period. Is it in fact easier to terminate an employee for cause during the probationary period? And the answer to that is yes, it is. But it is not a carte blanche to do what you want to do. The law around dismissal during a probationary period establishes a lower threshold. Again, as I mentioned at the beginning of the presentation, remember that the longer an employee works for you, the more consideration you have to give them, the more leeway they have, right? They've been loyal to you, and so you have to give them a fair chance. For new employees submitted to a probationary period, a court, or an arbitrator for that matter, will still expect the employer to act in good faith and to do a fair assessment of the employee. Generally, that means that you will, in fact, still have observations, things in writing, so to speak, or evidence at least from employees and so on, customers, to show that the employee is not suitable for the position. And it also generally means that they will be given a fair shake, maybe not during the full probationary period, but pretty close to it, right? Because you have to observe the employee. You still have to give them a chance to meet your expectations. Examples of things that tend to be a bit more convincing in that regard, as far as termination during a probationary period goes, would be something like, here's our standard process. You will have 5 evaluations during the 3-month period. And if you don't meet those evaluations, and this is the standard that we use for all employees, in other words, we are not acting arbitrarily in this case, then you will be discharged at the conclusion of that process. Okay, so yes, it is a little bit easier, but as I said, it still requires that the employer invest time with the employee, just not as much time as what we've been discussing so far. Now, discipline imposed in silos. These are questions that we get. Like, what that means was, well, what if an employee, swore at another employee? Right? Or was insubordinate. And we discipline them, but then one day they arrive late. What happens? Do we now suspend them for arriving late? They're kind of different things, aren't they? And so, generally speaking, you do have to, and we can normally find a bit of a common thread in the way that employees conduct themselves. They may be reckless, for instance. They have no regard for the employer's business and rules. But, and so sometimes you're able to kind of weave that story and kind of build on the discipline that you have. But when things are completely different, it's almost as though, you're going to be resetting a little bit the discipline. It all counts, but you're going to be advancing on different tracks of misconduct, so to speak, where some may lead to a written warning, others might be verbal, and then so on and so forth. We often also get the question, well, we have a zero tolerance policy, so we can rely on that, right? And the answer is it's relevant, but it is not determinative. And there's plenty of case law in the unionized and non-unionized world in that regard. Adjudicators will take those into account because it means that these are important rules. And so it says something about the employee who doesn't follow them. But your judgment, your rules are always subject to the just cause test that we've been looking at so far. So they are not sufficient in and of themselves. And it's the same thing that can be said about predetermined penalties. Just because you've arrived late 3 times and it says after 3 times you're terminated, that does not mean that a judge or an arbitrator is bound by those policies. So let's move forward to our next set of slides. Now we're going to talk a little bit about off-duty conduct. So as the name suggests, these are things that happen on the employee's own time. And let's move forward and hear from Boris with the Baraquillo case.
Thank you, Christian. So we'll be talking about employee misconduct off duty, including criminal conduct and conduct in online spaces such as social media. But first, I'll be discussing this case of Baraquillo and IQVIA Solutions Canada, which comes to us from the Ontario Labour Relations Board. And this is another case that deals with the duty of loyalty to an employer in the context of off-duty conduct. And we just heard Raphaël talk about employee loyalty, and this case had a similar positive outcome for employers on the whole. In this case, an employee was terminated for cause after the employer discovered he had set up a competing startup company. And this was despite the fact the startup company never really materialized into a business and did not really provide any services yet. So while the startup company was not in operation, it nonetheless had its own website. It had been incorporated, It was listed online. The employee was listed as a director of the company. And while it did not offer any services, the services that the company would be offering would have been in competition with those of the employer. The services being offered were the same or very similar and in the same general market. And the employee never disclosed the existence of this startup company to his employer. The employer only learned about it through one of its existing clients. The board concluded that the employee's conduct constituted willful disobedience under the Employment Standards Act, and therefore that he was not entitled to any statutory termination pay. And this is interesting because, as many of you know, the threshold under the ESA for losing in Ontario for losing entitlement to termination pay or severance pay is higher than the just cause standard at common law. In reaching its decision, the board emphasized a number of factors, including, first of all, that several of the employer's policies, including its conflict of interest policy and the code of conduct, expressly prohibited the kind of conduct that the employee had engaged in. Those policies all required the employee to obtain prior approval from HR for any outside employment, including self-employment. And the policies were clear that if you did engage in outside employment, you would not be providing services that are competitive to those of the employer or harm the interests of the employer. And importantly, the employee had been repeatedly trained and tested on these policies and was well aware of them. So he understood them and knowingly violated the policies. In addition, the employee was a manager and therefore a key employee within the company. And also he had recruited another employee of the company to work for that startup once they would start offering services. So given all of that, the board simply concluded this was disobedience within the meaning of the Employment Standards Act. The conduct was deliberate and intentional. And I should say, while the employee relied on a previous case from the Ontario Court of Appeal, which stated that planning to compete with one's employer is not grounds for dismissal, here the board said the employee's conduct went beyond just mere planning because he had a website, because the company was incorporated, because he had recruited another coworker to work for him, and that went on for a long period of time. So that was really the distinction. Next slide, and back to you, Christian.
Thanks. This is an interesting case, Boris, and certainly we've had questions in the past about employers finding out that some employees are doing activities on the side like that. And I just think it's really important to emphasize that the result would have been different if the employee had merely incorporated, listed himself as a director, and had not actually had a website, and which could be, you cross the Rubicon at that point, right? You are active in the new company. Plus, you are trying to poach some employees. So it's a little bit different because the traditional case law is more forgiving of employees who are merely, as Boris said, planning, and that might include incorporating and so on. Now, a couple of things. Alleged criminals in the workplace. We also get those questions every so often, I would say. Now, employees are generally entitled to do as they wish outside of work hours. Okay, so the both arbitrators and judges and so on have a lot of respect for employees' privacy. If you're going to terminate for off-duty conduct, you have to show a sufficient nexus between the conduct and the employment, and that is far from being obvious. And there are a number of cases where even things that one might consider to be quite egregious, participating in I don't know, a fight or harassment off duty that has really nothing to do with employees, clients, customers, or so on, or domestic issue, for instance. those are not necessarily sufficient to ground a decision to terminate. Again, you may decide that you don't want to have an employee like that in the workplace, and that is within your prerogative. You could terminate those employees, but you would be stuck paying for reasonable notice and whatnot. And in fact, I'm sure Raphaël will want to jump in after I'm done here, because a few provinces, Alberta, Quebec, British Columbia, there could be questions of discrimination when an employee is charged with something and it has nothing to do really with their employment. That is not the case for other jurisdictions, including Ontario. It is in fact legal here, so to speak, to discriminate against someone even if they have been charged with something and not yet found guilty. But you may be stuck paying for that. So it is a high threshold. When could you possibly terminate? And I will give you an example momentarily in a case, but it could be perhaps because there's overwhelming media attention. Okay. There could be quite a lot of attention about the misconduct because employees have learned about it in the workplace. And so the impact could be reputational harm to the employer, the image of the employer, and so on. Especially if you're dealing with someone who is client-facing or is in a leadership position otherwise, internally. It could be because of the impossibility, practically speaking, to manage the workplace, because some employees may refuse to work with the employee, right? They are now very concerned about what this employee may do to them. I don't need to tell you that in some circumstances, the threshold can be met perhaps more easily. There are some companies that are particularly well known and can't tolerate certain kinds of behavior, or there are, I don't know, school boards, for instance, can't have someone who's accused of improprieties towards youth, for instance, working in their midst, and so on. So all this to say, there are circumstances where you could terminate for cause. Generally speaking, the questions that we are often first faced with are whether or not we can suspend an employee. Does that amount to constructive dismissal, right? If we suspend an employee who's been accused of something, and should we pay the employees while the criminal charges are pending and while we may be doing our investigation? So let's look at that. Next slide. Briefly, this case is from 2021, so not so old, Sunwing Airlines, and it involved two employees who were involved in a romantic relationship. One was a pilot, and the other one was the first officer. The captain, I should say, and the other one was the first officer of the captain. So they would be called upon to work together closely, and this was a domestic dispute. There's not much details as to what exactly happened, but the griever, the pilot, the captain in this case, was charged with assaulting his girlfriend while he was off duty. I understand that the altercation occurred while he was I think visiting her family. So the mother-in-law or whatnot was present. The grievor, so the pilot in this case, was faced with a peace bond where he could not, in fact, contact his coworker. So that's a big deal because it is a legal requirement, of course, that prevents them from being in the same quarters, the same vicinity, and certainly from working together. The peace bond was going to last for 8 months. Some of the probably more critical things that happened in this case, and that might have tipped the balance, but it's not the only thing, was the fact that the grievor had not, in fact, disclosed what happened to the employer, and viewed it as a very private matter, and kind of held that tune even as he was confronted during an investigation. And that is, again, despite the fact that there was a peace bond ordered against him, right? He had undertook not to be around her and so on. Ultimately, in this case, the grievance was dismissed. In other words, the discharge was accepted. and by the labor arbitrator. And why was that? Well, there was in this case a nexus to the workplace. This is perhaps a little bit more obvious because the two of them work together. Now, what is perhaps less obvious to you as you read this is that it was very difficult for the employer in this case to mitigate the risk that those two employees would find themselves working together in the circumstances of this case, in part because of the vagrancies of how scheduling works within the industry. Sometimes you've got a flight delay, you got cancellation, you got somebody who's sick, and so things get reorganized. And so it was not impossible that these two employees were going to work together. And both of them, of course, would have been also, let's bear that in mind, separate from their colleagues, right? Because they would be in the cockpit. The door is closed. Everyone else is in the back. The employee, the female coworker in this case, had also expressed concern about working with the pilot, had also expressed concern as well about some forms of reprisals, advancement on her career. He was much more senior than she was. And this goes to one of the questions I saw in the chat. The pilot here was in a position of trust, right? He works independently. It's not like he's got anybody to supervise. He's in an airplane and he's giving directions and so on and so forth. And so that there is a higher expectation placed upon people in positions of leadership. So that's very important here. And also, pilots are in a certain way, and this was brought to the attention of the arbitrator who accepted it, pilots are the face of the airline in a certain way. And airlines are very public organizations, commercial as they are, and people can make decisions as to where they're going to shop based on that kind of controversy. And so all of these things combined played together to discharge the pilot. Let's go to the next slide. And let me just tell you briefly to answer these common questions that we get. Can I suspend an employee with pending criminal charge? You have to show that there's a reasonably serious risk to your interest as an employer. Could be matters of safety, could be matters of reputation, could be matters, as the case I just discussed, of difficulties or impossibilities to manage the workplace. But you also have to consider the possibility of mitigating risk. So that makes it rather difficult to suspend an employee pending criminal charges. What it does mean is that you would have to investigate to form an idea as to whether or not that would be appropriate. Must you pay an employee? The answer is yes. It would be under very exceptional circumstances, and there are very few cases where you could justify not paying an employee while they are awaiting their trial, right? Obviously, this takes into account the fact that the employee is not in jail, right? They're able and available to work. Now, speaking of jail, can I terminate an employee who's in jail? The answer to that, surprisingly, is not as clear-cut as you would think. It depends on the nature of the employee. Why? Because there's a balancing of interest approach that is privileged by judges, by arbitrators, and so on, meaning that the employee has a presumption of innocence. We don't know if what they did was criminal or not. There's been no trial. And so we have to see if it's possible to mitigate, I'll use the word accommodate, though this is not a human rights matter, but to accommodate perhaps the employee by granting them a leave of absence. So that's very important. That being said, for those of you who have a pen and pencil or are typing on your computer, there is a case that's quite recent. It's from Ontario. I'll give you the citation. It's 2024 Canley, CANLII 3322. And that case, a gentleman was terminated, and that was for frustration of contracts because they were in jail and at the time had not formally requested a leave of absence, and it was unclear how long the employee was going to be in jail for. And it's important to note that for this particular employer who was running a farm, they needed this person as a farm manager to be on site to do the job, particularly as a particularly busy season was coming was anticipated shortly while the employee was in jail. So in that case, frustration of contract, no obligation to pay anything to the employee, but it's not just cause. Okay, so that's important to note. The impact of the criminal trial, well, if there's a finding of guilt, that can typically be imported in arbitration or in a civil case, right? Because it's a high threshold to meet. The burden of proof, think of O.J. Simpson, right? It's beyond a reasonable doubt. So if you manage to do that, then you've proven the balance of probability piece in a civil matter. Now, if the charges are dropped or there's an acquittal, well, you should still be investigated and determining what you should do, right? So we go back to the top. So on that note, let's move forward to the next slide.
Thank you.
And who is that?
I'll take it back from here, and I'll address Christian's comments about the consequences of a criminal background or things akin to it when discussing this case. Even if this one is about social media, you'll see that there's a little bit of a parallel that can be done between the two. So in this very recent case of 2023, in the Metrolinx case, the employer had terminated a group of employees who had made absolutely outrageous comments in a WhatsApp group chat about some of their coworkers, mostly female coworkers, and mostly very sexual and crude comments. Those comments were made in private in that group chat that where only a few employees were present on and were communicating on. And HR was only made aware of it a number of months after the messages were exchanged as part of another investigation where it met with one of the managers who said that an employee had come to her and showed messages a few months ago and didn't think that it was anything too complicated or anything too outrageous. So the situation stayed there without the matter being escalated to HR. Now, once HR is aware of that, they run a proper investigation regarding the comments that were made on that closed group chat. And they force one of the employees who doesn't want to provide a copy of the screenshots or a copy of the content of the communication. They force him to do so, threaten him with discipline if he does not collaborate in giving it. So once all of the information is now being known to the employer, because the employee eventually gave his cell phone, personal cell phone, in order to have the information reviewed by the investigator, HR finishes their investigation and concludes that all of those employees committed sexual harassment and therefore need to be terminated. The arbitrator first has a long statement about whether or not the social media closed group chat could be used at trial and if it could be used or even given access to the employer, and determines in the end that the text messages were shameful. They reflected poorly on their character of the individuals, but they occurred outside of the workplace. They occurred on the own free time of those employees and using their personal cell phone. They used WhatsApp, which is also an encrypted application where the content may not be transposed elsewhere, which showed that those employees intended for the discussion to remain private. The arbitrator concludes that the employer did not have a license to intrude in their private electronic conversations unless they had express authority to do so, whether by consent, court orders, or other things of the sort. Consequently, the arbitrator grants the grievances and reinstates those employees or provides them with severance. They also found that the employer failed to establish the off-duty misconduct, they failed to establish that the off-duty misconduct had a negative impact in the workplace because the employees who were referred to in that group chat were unaware of their content. It had not created a hostile or poisoned work environment. So situations such as this one put employers in a little bit of a pickle situation where they may become aware of certain facts or certain events, and they learn it in a way that makes it that the evidence may not necessarily be used at trial or may not be used to discipline somebody. This is not different, to go back to what Christian was talking about. It's not different from an employer running a background check on an employee, or an employer being made aware that an employee has a criminal record, and then being outraged at what the employee may have done, whether on his off time, whether before being an employee. But if there is no relationship between that criminal record and the employment, here in Quebec, the charter would protect that employee from any sort of retaliation, such as dismissal, refusal to hire, or the employee being penalized owing to the mere fact that they were convicted of a penal or criminal offense. So there are those situations where an employer either wrongfully or not delicately becomes aware of certain situations, and they may find them outrageous, but there's limited things they can do about them. In this case, the individuals had kept the discussion to themselves. It had not transpired in the workplace, and it had no consequence on how the employees felt. So the arbitrator concludes that those comments could have been made at somebody's backyard at a barbecue, and nobody would have known about it comes Monday morning, and the employees would therefore not have been disciplined. It reminds us that we need to be very careful when it comes to how we obtain certain evidence, because we may then be stuck with it and not be able to use it. If we move to the next slide, in Cameron, it's pretty much the opposite. You have an individual who works for a school board and is also the parent of kids who go to that school. The parent makes a very polite statement on Facebook about whether that she has certain concerns about her kids, about how the school will help kids who require special assistance, that she's nervous about meeting with the school and discussing this, but she also says a lot of good things about that school, about how the people are engaged, and she's excited for the new year to start. The comments are not defamatory, not derogatory. They do not contain any criticism of the employer. In fact, the employer's name is not even said in the post. A week after having done that post, she files a complaint for harassment against her boss, and the next day she receives a letter that she's being investigated on about that Facebook post. She's then terminated owing to that post, the employer saying that the comments were inappropriate, that it alleged that the employer denied services to clients, treated them differently on the basis of their status, that it impeded clients' access to services, and that she alleged that employers stopped clients from receiving the best help while developing in school. And they also claim that she used confidential information in writing her post. All of those allegations are not proven. The tribunal even states and quotes the comment that was made on Facebook to show how benign it was, and eventually grants the demand and reinstates the parent in her position, because that's what she wanted. She still loved her job and wanted to stay there. So that being said, I can pass the ball to Christian for a little bit on human rights.
Yeah, and before I talk about that, since we've got a couple of just quick questions on topic, because I'll only spend 2 minutes on the human rights piece for now. Someone asked about the case on jail time that I cited. What is the citation? It is 2024 Canley, which is CANLII 3332 from the Ontario Labour Relations Board. Funny enough, the case involves a gentleman by the name of Adam West, and it is not Batman So, okay, there was a question about the social media case, which Raphaël just talked about. Could it have been appropriate if an employee within the group had filed a complaint? And I think I just want to be clear on that case. There are other cases where chats have attracted dismissals. And there's one case, and I'm probably mispronouncing it, or I think it's Terra Algoma, if I'm not mistaken. That's just one of them that comes to mind. And when employees become aware of these things, it's a different story. And of course, it could be a different story too if the things that were said were really egregious. And as I recall that other case, there were things that were very, very terrible that were said about the employee. I mean, threats of violence and so on. And so those are different cases. Sometimes the privacy settings are not so private, and other people kind of the group becomes large and people pile into the conversation, or maybe it's done anonymously in a public forum, but in such a way as everybody knows who we're talking about. That is off-duty conduct that is different, and that would attract discipline, and depending on how bad the comments are, possibly discharge. So I think it's important to know that. Other than that, I know someone has asked a question as well about what about the issue of employees, and that's probably in relation to the case Boris talked about. Can we ask employees if they hold directorships in other companies or have private businesses outside of work? There's nothing illegal in asking that question. And in fact, most of these records, they're private. They're public. Pardon me. You can run searches, right? They're government filings. If people are directors and corporations and whatnot. So I don't see an issue. Most employers will just have more of a conflict of interest policy and ask us employees to sign. And if it's later determined that they have been lying or whatnot, then there would be cause for discipline. So human rights predicaments, let's move forward. I just want to give you two cases that contrast one another. This one here, it's not a new case, but it is nevertheless interesting and instructive. Regional Municipality of Waterloo, Sunnyside Home. This was a nurse who was stealing opioids, and what is really, she was terminated, she was discharged. I think what's really critical to remind everyone about this particular case is that there was medical or expert evidence that her particular substance disorder, and these, by the way, are paragraphs taken from the case. I should have mentioned, or I should have marked those down. It's paragraph 174 of the case. I am not plagiarizing here. Paragraph 174, everyone. And the focus here is what is the effect of the disability, on the ability of the employee to comply with the rule, right? Or the expectation. In this case, don't steal the medication of patients, right? And there was expert evidence on the compulsion here, and it was a very peculiar case for that reason. All right. Now let's go to the next slide. By contrast, this next slide is a case of 2011. And here is someone who had a cocaine addiction and who was stealing copper wire from the TTC to sell it to purchase an 8-ball of cocaine. All right. Now that is different. And as you can tell, again, these are paragraphs as well. If you're interested, they are paragraphs 109 and 110 respectively of the decision. You can see here, quote, additionally, I accept the evidence of Dr. Resnick that there is no causal connection between the griever's misconduct and his dependence on cocaine. This is our last slide. And the point here that we're trying to make when we talk about human rights is that the employees will come forward with a human rights or disability, or it could be other things. I mean, could be age, could be something else, I suppose. And they will try to excuse, right, their misconduct, or their performance on that basis. It is difficult to handle as an employer, but I think I want to leave you with two important points in that regard. The first one, as you can tell specifically from the two contracting cases that the two contrasting cases, pardon me, that we just looked at. The employee has to be able to show that the poor performance or the misconduct is a direct consequence of the disability. That is not necessarily an easy thing to do. That's the first thing. The second important point, and it's a corollary to the first, is that as an employer, you are entitled to get quite a bit of information about the employee's disability. Why? Because you are in the realm of accommodation. And for those of you who attended Boris and I's presentation last year, you will see that there's some useful slides in that regard. You're entitled to more information when you're talking about an accommodation rather than just excusing someone's absence, right, for a few days or so on. So bear that in mind, seek legal counsel, but don't be afraid to follow up, to challenge the doctor, to maybe get a second medical opinion, right? Because the employee is asking you for an accommodation, i.e., please excuse my performance or my misconduct. As far as performance goes, the long and the short of it is, if an employee has a disability, you have a duty to accommodate the employee. So we could spend a long time talking about all that. But that means that perhaps some of the tasks of the employees, not the essential ones, but other ones, are going to be taken away, replaced with other things. Once the employee is accommodated, again, we're expecting the employee with accommodation to be able to fulfill the essential duties of the job, right? But there is quite a bit of reflection that you have to put into the accommodation, to the expectations that you have of the employee, to make sure that they have what they need to do the job. And then, yes, you can move forward with the performance evaluations and so on and so forth. And the same goes for the misconduct. So just remember that the employees, the onus is on them effectively to show you that they need that accommodation, and you are allowed to collect information. So on that note, I would like to answer a few questions in the time that we have. So if you have some and you would like to put them in the chat, we are looking at them. One question, and I'll let Boris and Raphaël intervene, but there's a question on what is the onus? Is that, do employees who are in a managerial position have a different standard that applies to them when it comes to managing their performance or their misconduct?
Well, I can comment on that. I think managerial employees may be held to a higher standard, in my view. Going back to Christian's comments about probationary employees, they're perhaps held to, we talked about the amount of time that a probationary employee is I'm going to use the word entitled to satisfy an employer's expectations. We talked about 3 months. We talked about 3 to 6 months for employees who have certain performance concerns. For managerial employees, they're already sort of in a role where they're expected to be performing at a certain level. They're not just in the early stages of their career. They've already made their way up the ladder, and in that sense, if a managerial employee and necessarily their responsibilities are more important, there's less leeway, there's less room for maneuver in terms of mistakes and performance concerns. So generally, those employees would be held on a shorter leash, so to speak, if you're the employer.
I fully agree with Boris here in Quebec, and an employee who is a manager, we're expecting a lot less leniency. We're not going to have another manager assist them and and give them a massive amount of assistance in order to determine whether or not they can do the job or not. And there is case law in Quebec that is a lot less tolerant against an incompetent manager than it is towards an incompetent employee. Also because of the fact that the manager has to lead by example, and we're expecting somebody who has a good performance to act as a manager.
There was another question, which I thought was also interesting. So how is it? So when does an employer move from being supportive, coaching, to a disciplinary approach when there is a performance issue? And I will say, generally speaking, when it's truly a performance issue, as opposed to an employee who's being reckless, right? Just, doesn't care. I'm giving you a deadline and you're not following it, right? As opposed to you are entering data and you keep making mistakes. One of them is a coaching approach. It's a performance improvement plan. The other one, somebody who's really not following, specific instructions. That is more of a disciplinary approach, more of a misconduct approach. Now, you could straddle the line and decide to put everything in the evaluation piece. Just make sure that you're not kind of double dipping and penalizing the employee twice for the same thing. It is perhaps more relevant in the context of a unionized workplace than it is in a non-unionized workplace, but I am sure that judges would be very attuned to that nevertheless, and would want to make sure that employees aren't treated unfairly.
Well, I think, Christian, we received some comments from attendees just generally asking us to speak about the differences between federally regulated employers and provincially regulated employers. And you said at the very outset, Christian, that it's pretty uniform across Canada, and that is true. But one thing we would stress for federally regulated employers is that, well, generally speaking, unless the employee has been there for a brief moment, or unless we're dealing with a managerial employee, you must have cause to terminate, or if there is a restructuring in place, that's a different story. But I just want to touch briefly on the consequences of not meeting the threshold for just cause at the federal level. The consequences are much more significant, in my view, because at the provincial level, if you don't attain the threshold, the worst that can happen really is the employee will be entitled to reasonable notice at common law. And that'll be a few months. It'll be based on the Bardell factors and the common law provinces. But at the federal level, the employee could be reinstated or could receive compensation in lieu of that reinstatement. And if the termination took place a long time ago, and you're now a couple of years out and still awaiting a hearing date, which is a common occurrence nowadays with the backlogs and the court system, you could be facing a significant financial consequence if ultimately you're not successful in proving your case. So I think that would be the main distinction.
Yeah, go ahead, Raphaël.
Oh, yes, and maybe just to add to what Boris said, in Quebec is a little different in the sense that the Act Respecting Labor Standards provides for the ability for an employee to be reinstated if the employer does not prove that it has a just and sufficient cause to terminate him, which would require that we meet all the criteria to confirm that somebody is incompetent. And the employee always has two choices. He can go before the TAT based on the Act respecting labor standards. He could also go where he can get reinstated if he's not a superior manager. And he can also go in front of the Superior Court and seek an indemnity in the event of notice of termination, which then is only a monetary condemnation, but reinstatement and the money between the termination and reinstatement minus mitigation is often the trigger point for employers to settle early instead of settling or going to trial and eventually being liable for tens of thousands of dollars.
Yeah. And so on that note, everyone, what we tried to do today was give you a little bit of a sample of different scenarios for termination. And we really hope that this was helpful to you. We're trying to give you tools not only to inform your decisions, but to assess your risk. And sometimes that's all you can do, assess your risk. And even if it's you got an employee who maybe breached a really important rule, maybe even a health and safety thing, but you just don't want to tolerate it, maybe you'll make the decision at the end of the day that you'll take your chances, hope the employee mitigates their damage, and move forward. So on that note, thank you. Thank you for joining us today. To my fellow speakers, Boris and Raphaël, it is always a pleasure. On your screen, you now see the QR code to our survey. If you have not yet filled out the survey, it only takes a minute. Again, we really appreciate the feedback, all three of us and our colleagues. And I will take this opportunity to plug our next LEHR webinar, which will be held in mid-April. The registration for the event will be opening up soon. You can register either from the invitation or from the Fasken Institute section of fasken.com. Have a wonderful day and see you soon.